Judge Brower is a former judge of the International Court of Justice and of the Iran-US tribunals. He has experience of many international dispute resolution cases. He worked also for the firm of White & Case and established their Washington office. As Assistant General Counsel for the Asian Development Bank, I've engaged and worked with White & Case a lot, and especially with the Washington office. Judge Brower has served, as I mentioned, on the Iran-United States Claims Tribunal in The Hague, in Netherlands, and as an ad hoc judge of the ICJ. In 2015, Judge Brower was only the 4th ever recipient of the Global Arbitration Review Lifetime Achievement Award. So we're very fortunate to have Judge Brower with us, who comes with very distinguished experience and distinguished career. Judge Brower, if I can ask the organizers to put you on the screen. I hope you can see us all. I hope that the camera enables you to see the audience as well. Please. Judge Brower, we can't hear you. Perhaps, are you muted? I'm just wondering. You can just check. And I've asked the organizers to also check. Why not?
I am not muted.
We can hear you, sir. Go ahead.
Okay, thank you very much. Before I say anything else, I wish to express my personal sympathy and that of my country regarding the terrible floods raging in Pakistan and the resulting loss of lives. It truly is a monumental disaster, and we all sympathize and we pray for those who are affected by it. On the occasion of this conference, which is being held under the auspices of the International Center for Appropriate Dispute Resolution and Prevention, ICADRP, of which, as mentioned, I have the privilege and honor of being its chief patron, and which conference marks the formal launch of that ADR center and the commencement of its formal operations. I welcome all of you, recognizing especially the presidents today of Chief Judge Minallah, Judges Aurangzeb and Ishaq Khan, also Minister Tarar, and any other judiciary present today. But I also want to welcome two longtime special friends of mine. The first of them is Ms. Meg Kinnear, the illustrious Secretary General of the World Bank Group's International International Center for Settlement of Investment. Today. The second, however, is none other than Pakistan's and Islamabad's very own Dr. Nusrat Piracha, the Chief Executive Officer of the center that has organized this conference and makes its formal debut today. She is the only Pakistani woman to have earned the degree of Doctor of Juridical Science, SJD, which is the highest law degree that can be earned in my country, the United States of America. Beyond that, she is one of the only 3 Pakistani nationals currently appointed by the government of Pakistan to the panel of arbitrators of the aforementioned ICSID. Furthermore, recently she was appointed by the president of the World Bank to a 3-member ICSID ad hoc committee established to adjudge whether or not a particular ICSID award should be annulled. Pakistan should be very proud of Dr. Piracha. Now, I, as one who has spent half a century practicing alternative dispute resolution in its many forms, in government, in private practice, and as a judge of the International Court of Justice, the Iran-United States Claims Tribunal, and the Inter-American Court of Human Rights, and now, as mentioned, as chief patron of the Center for Alternative Dispute Resolution and Prevention here in Islamabad, I attest wholeheartedly to the efficiency, the efficacy, and the fairness of ADR. Many countries are turning more and more to ADR. Echoing something I believe was referred to in a previous presentation, I am reliably informed that Turkey, for example, has more than 300 private or commercial ADR centers, which within a recent period of 3 to 4 years resolved 3 million disputes. Since Turkey has a population of about 85 million souls, which is only 37% of Pakistan's population, the numerical result could be in Pakistan if it would have a number of ADR centers proportional to those of Turkey. I understand that currently Pakistan's courts have roughly 2.5 million cases on their dockets, approximately 53,000 of which are pending. Would be eased by a broader availability of ADR centers providing high-quality services of well-trained and experienced mediators, conciliators, arbitrators, and other practitioners of the ADR arts. I do not for a moment exclude courts referring litigating parties to an ADR forum, which I understand is gaining traction in the courts of Pakistan and has been a very successful situation in my opinion. The proof of ADR success is in the ADR pudding, as it has developed around the world. Purely domestically, the spread of ADR in Pakistan should be a blessing for all disputing parties who would want justice to be done in a manner that functionally is timely, very timely. Moreover, the external benefits of ADR overall are helpful in attracting foreign investors. Unless, of course, the so-called investor is a state or entity of a state whose goal is political penetration of the host state, such as, for example, the use by communist regimes in the past of their foreign trade organizations during the Cold War to invest abroad for strictly political reasons, irrespective of economic considerations. Much of my own experience has been gained in dealing with disputes arising between private foreign investors and their host countries. Now, anyone familiar with this field understands very well that every foreign investor will price its proposal, its preparedness to invest in the foreign country, taking into account the risks involved, both commercial and political, taking into account the political risk. One looks in part on the extent to which the investor believes that in the event of a dispute with the host country or its contracting counterpart, there will be available to it a fair, impartial means of resolving that dispute. If the foreign investor is not satisfied on that point, it may just decide not to invest, period. Alternatively, A foreign investor may decide to invest, but at a price elevated sufficiently to cover the risk. This means that the greater is perceived to be a risk of that type, the higher the host country must pay for the investment. Given the limitations on a host country's financial resources, added to the potential restrictions on funding from international financial institutions, a host country may find itself paying more money for less investment than would be the case if the foreign investor were convinced that in the case of a dispute, it could resort to a truly trustworthy forum for its resolution. Now, in this respect, I note favorably that Pakistan is a party to the ICSID Convention and also to the New York Convention. I recommend that I consider becoming also a party to the Singapore Convention on Mediation. That convention has been signed by 55 states. They do not include Pakistan at the present time. And to date, 10 states have become parties to it. That convention is great for ADR. Stating that the judicial branch of a state party to it generally must enforce the outcome of a mediation. As to the effect that Pakistan's current model bilateral investment treaty may have on the risk calculations of foreign investors, having myself studied that model bilateral treaty, I can only say at this point that it remains to be seen what its effect on foreign investment may be. Thus it is that based on observed and personally lived experience, I declare that ADR in all of its forms is on the march around the world and should be embraced both by courts as a speedier means to the resolution of disputes on their dockets, and by disputing parties as a way to a fair, impartial, and judicious resolution of their differences that is achieved in a quite reasonable period of time. It's helpful to those who need to solve a problem. It has the power to relieve overworked courts, and it can contribute to greater inbound investment at a lower price than otherwise. So I encourage the training in ADR arts of appropriate personnel, the establishment of sound ADR centers, pardon me, with well-trained, experienced experts in the various ADR forms of timely dispute resolution, as well as the education of judges, if I may, in the advantages and the trustworthiness of ADR. If enough people are favorably impacted by the advantages of and the downright need for utilization of ADR methods, and it thus grows in popularity, the necessary financial investments to put ADR on a fast track to broad utilization of it will follow. I wish all of you well in this highly moral endeavor, and I thank you for your kind attention.
Thank you very much, Judge Brower, for your remarks.